Good morning. I'm Carrie Odell. I'm the Deputy Assistant General Counsel of the Ethics and Appeals Division, and thank you for joining us today. As everyone knows, we are about to have a presidential election, and no matter what happens, we are going to have a transition. And transitions bring a record number of employee departures, not just from our political appointees, but around this time, we have a lot of career employees who think about retiring or finding their way in the private sector. So we are providing the spot training today to inform you about the rules that apply to seeking employment and post-government employment. And now I'm going to turn it over to my colleague, Debbie Deuster.
Good morning. My name is Debbie Deuster, and I'll present to you on seeking employment. For our discussion today, we want to keep two things in mind. For the seeking employment rules, we're really discussing employees seeking employment or applying with employers who are private or non-federal entities. So we're really not talking about our transfer employees or our federal employees seeking a position with another federal agency. Secondly, the seeking employment rules do not prohibit employees from where they might want to seek employment or find a new position. It's really a focus on what you may be working on while you're still in federal service and communications that you may be having, because there's the potential of having a conflict of interest. So, to avoid a conflict of interest, it's important to know, when am I seeking employment? So you've begun seeking employment anytime that, for example, you have started engaging in negotiations for employment. So those are the typical conversations, such as what the position duties are, a title, pay, benefits, or a start date, as an example. You're also seeking employment anytime that you have made an unsolicited communication for employment to a particular employer. And you are also still seeking employment any time that you have received an unsolicited communication for employment or a proposal from a potential employer where you have not made a response, or where you have made a response other than a rejection. So we have an asterisk by rejection because under the rules, technically, a rejection must be an unambiguous response. So you cannot defer discussions or make another type of response. You cannot say, I'm interested, but later this year. You've deferred discussions. You have not actually made an unambiguous rejection. So, still guarding against conflict of interest with a particular employer or a particular employer you're applying with, when are you no longer seeking employment? So an employee is no longer seeking employment when you or the employer have rejected the possibility of employment and all discussions have terminated, or 2 months have passed since you sent an unsolicited resume or an employment proposal. So again, we have an asterisk, and so specifically under the regulation, for the 2 months to expire, the intent is that there has not been any interest expressed by either the employee or the employer in the potential for employment. So if that's not the case, you need to make an actual rejection. So again, with our concern being not incurring a conflict of interest while you're still in federal service, what do you do when you have begun seeking employment? Once you have begun the process, employees are prohibited from participating personally and substantially in any particular matter that would have a direct and predictable effect on the financial interests of a prospective employer. So in that case, under 18 U.S.C. 208, our statute, and the regulation 2635-604, an employee must recuse or disqualify themselves from any duties which might violate this rule. So as you'll remember from your annual ethics training, you participate personally anytime that you have direct input. It could be a decision, an approval, a recommendation. If you're providing advice, you participate substantially if your involvement is of significance to the matter. And a particular matter, as you recall, we usually describe in terms of, think of a contract or a grant. That would be a claim, a litigation case. Those are all matters involving a specific party, a grantor, the contract, the vendor, as an example. However, you can also have matters that involve parties that include state and local government entities. It could include a nonprofit and its affiliates, as well as you could have a party matter, a matter that is before HUD, that the potential employer is one of many parties in which the decision by HUD could impact that employer. So the advice from our office is that you err on the side of caution. Once you begin seeking employment, go ahead and have a conversation with your supervisor, look at the matters that you're handling, and complete a recusal. If you need any help in deciding on these matters, please reach out to our office, as well as we have a template for a recusal that we can help provide you.
So now we're going to have some considerations for additional positions. I'd like to talk about the Procurement Integrity Act, and you're thinking this is an ethics class. What is this doing here? Well, we have a lot of contracting officials at HUD. So the Procurement Integrity Act means that for employees having certain roles over contracts valued in excess of $10 million, you cannot receive compensation from the winning contractor, either as an employee or a consultant, for 1 year after those contracting duties end. So what kind of roles? We're talking about contracting officer, program manager, deputy program manager, basically any ability to make, award, or modify a federal contract in excess of $10 million. And it ends 1 year after the role ends, not necessarily when your employment with the federal government ends. Now, we're going to provide our information for our friends in procurement if you need help figuring out if you have one of those roles. But unlike the rest of the rules that we're going to discuss today, if you have one of these roles, you cannot go work for that contractor. You have to wait. Now, if you are participating in a procurement over $250,000 and you receive an offer of employment by a bidder, or you contract a bidder regarding employment, you have to notify your supervisor and the designated agency ethics official in writing, and we're going to provide our contact information at the end of this presentation. And you must either reject the possibility of employment or disqualify yourself from participating in that procurement. Now, this does not apply after the contract has been awarded. However, you would still then have to recuse under 18 U.S.C. 208 if you were seeking employment with that contractor. And 18 U.S.C. 203. So now all of you know from your ethics training that you're not allowed to represent others before the federal government, and that includes any federal court or any federal agency, in any matter in which the U.S. is a party or has a direct and substantial interest. Now, 18 U.S.C. 203 goes even further, and it says that you cannot derive compensation from others' representation of another before the federal government in any matter in which the U.S. is a party or has a direct and substantial interest. Now, while this rule applies to everybody, this is typically a problem for lawyers, so I will use a lawyer as an example to explain. A lawyer leaves the federal government and accepts employment with a law firm as a partner, and they have equity interest. And that first week the new partner is there, the law firm receives proceeds from a lawsuit where they represented another against the federal government, and pursuant to their equity agreements, all the partners get a share of that money. Well, guess what? The new partner cannot get that money because all that work was done when the new partner was a federal employee. Now, 203 does not apply to your salary. It does not apply to compensation that you earn through your own efforts. It's a timing issue. So often places like banks, other places that HUD employees may go work at after they leave the federal government and they offer an equity interest, they'll typically wait a while for that equity interest to kick in. So if you are looking at employment that involves an equity interest and you're not sure if the arrangement is going to comply with 203, please contact us.
And so in general, employees are permitted to seek employment on all the usual platforms and outlets. So for example, you're permitted to post your resume online, like Indeed or LinkedIn, to use a recruiting agency or headhunting service to help you find a new position. And obviously, you can also use your social media to post your resume or to inquire on a particular job opening or position that may be available. So let's review with some examples, and we'll put Carrie on the hot seat here. So, question 1. Cardi calls Baxter Worldwide solely to request a job application. Is Cardi seeking employment?
No, Cardi is not seeking employment because Cardi has not taken an affirmative step yet to apply for the position.
Second question. Alvarez posts a resume on social media and sees that K-Bell EPLD International has viewed and downloaded the resume. Is Alvarez seeking employment?
No, simply having your resume on social media or a job site is not seeking employment.
What if the company calls Alvarez, but he does not take the call or does not respond?
So if you receive an unsolicited offer of employment and you do not respond, you're not seeking employment.
What if the company calls Alvarez and he takes the call and he engages in a responsive conversation?
Okay, so now if Alvarez takes that call and he responds with anything other than a no, he is seeking employment and must recuse.
Third question. Jamari utilizes Bowling Gale Force Operations Company's website to upload a resume for a particular job opening. Is Jamari seeking employment?
Yes. Jamari has now taken an affirmative step to apply for that position.
Fourth question, last question. Andy calls the HR office at Damon's AAA OGC Incorporated to ask questions regarding a particular job, recruitment, or posting and possible application for that job. Is Andy seeking employment?
Not yet. Right now, just finding out information about a position is not seeking employment. He would have to take an affirmative step, such as applying for the position. And some more additional requirements. So for those of you who file the OGE 278 Public Financial Disclosure Report, these are our political appointees, our career SES or SL employees, you have an additional requirement. When you start engaging in negotiations with a non-federal employer, you need to submit us a Stock Act form within 3 business days. Now, the key word to think of here when that form is required is mutual. So simply sending an application, if you file the 278, you don't owe us the form yet. But at the point that you start having the job interview, when the discussions are mutual with an idea of accepting that position, now you owe us the form. And our contact information is going to be at the end of this presentation. Now, it's not a bad idea to send us the form a little early. It doesn't hurt. We also have an example of a recusal statement that you can provide if needed. And now what everyone's been waiting for, now we're going to talk about the post-government employment rules. And I want to just remind everybody that these rules that we're going to discuss, they're not going to prevent you from taking a job. They're just going to limit what you can do for that non-federal employer. All right, so the first rule that applies to all employees, you, me, everyone, it's called the lifetime or permanent ban. You are permanently barred from representing your new non-federal employer back to the federal government on any particular matter involving specific parties in which you personally and substantially participated as a federal employee. What is a particular matter involving specific parties? Well, it's like Debbie was discussing. It's a contract, an application, a litigation. There are non-federal parties on it when you worked on it. There are specific non-federal parties at the time your new employer wants you to represent back to the government. It does not have to be the same parties at the same time. And the lifetime ban, it doesn't last for your life, it lasts for the life of the matter. So let's talk about that contract. Let's say you wait the year and you took the position on that contract. You're not going to be able to represent your new employer back on the contract. But if that contract gets recompeted and the same contractor wins it, the regulations provide that now it's a new matter. Now, if you're subject to the lifetime ban, you can still take the position. It's just for those matters that are subject to the lifetime ban, you are limited to providing behind-the-scenes assistance. So you could give your new employer your insight, you could give them advice based on information that wasn't confidential. You just can't go to the meetings. You can't be on the letterhead. You can't be on the email. You are limited to behind-the-scenes assistance. Now, the next rule that applies to everyone is called the official responsibility ban. It's the same matters, particular matters involving specific parties, but instead of you participating personally and substantially in it, someone you supervise does all the work, and they maybe report to you once a month in a staff meeting. You don't even have to be a supervisor for this to count. You could be a mentor or a team lead. So we're going to look at your last year of federal service, and anything that fell under your official responsibility during your last year of federal service, you cannot represent the new non-federal employer back to the government on those matters for 2 years. You are limited to behind-the-scenes assistance. However, and if you're not an official supervisor, you do not have official responsibility over your own work. It is not a catch-all for things in which you did not participate personally and substantially that would trigger the lifetime rule that we just discussed. And now I'm going to talk about rules that apply to fewer and fewer categories of employees. And the first rule is the cooling off period for senior officials. Okay, so who is a senior employee? A senior employee occupies any of the positions levels 1 through 5 of the executive schedule or makes a certain basic rate of pay, and every year that number changes. So for 2024, the basic rate of pay is $191,944. It does not include locality pay, so a GS-15 Step 10 is never a senior employee. So if you are a senior employee, you can't represent anyone, any non-federal employer, back to your agency, including in subcomponents, for 1 year after you exit the senior position. And exiting the senior position, as opposed to the government, is very important. For example, we have a non-career SES. They are subject to a pay freeze this year. So this year, they're not making enough to be senior officials, but in 2023, they did. This is a few employees this is subject to. So for those employees, they actually exited the senior position on January 14th, 2024. This clock is running now. But if you are a senior official, you are subject to the cooling off period. You can still take the job. You can provide the behind-the-scenes assistance. You just can't represent on any matter and before HUD, before all of its components for 1 year. If you're a very senior employee, this would be the vice president or cabinet level officials, this period is extended for 2 years. And if you're a senior official, either way, there's also a 1-year foreign assistance ban. So you may not represent a foreign entity before or advise a foreign entity with the intent to influence an official decision from an employee of the U.S. government for 1 year. And then we don't have many employees at HUD who are involved in trade or treaty negotiations. But if you are, we're looking at your last year of federal service, any trade or treaty negotiation in which you personally and substantially participated during that last year. You cannot represent anyone other than the United States for 1 year. Now we have additional restrictions on our political appointees. They sign the president's ethics pledge. And if you are a senior employee, because you meet that salary or position threshold, the pledge extended that cooling off period for 2 years. Additionally, it prohibits shadow lobbying for senior officials, so they may not materially assist others in making the communications they are prohibited from making for 1 year. There is a 2-year ban for senior officials on engaging in any activity on behalf of a foreign government or foreign political party that would have required them to register as a foreign agent. And for everyone who signed the ethics pledge, not just senior officials, you cannot lobby certain covered executive branch officials for the rest of the administration or 2 years, whichever is later. We know when the administration is ending, and those covered officials include the president, the vice president, any military officer 07 above, anyone who works at the executive office of the president, any career SES, non-career SES. You're not allowed to lobby those people for 2 years.
So let's review with some examples. We'll put Carrie on the hot seat again. First question. If I had to do the same again, Fernando is a retired multifamily division loan reviewer and has been approached by a law firm to work as an independent contractor reviewing residential loan documentation for compliance for a bank. Can he accept?
Yes, he can, but we're going to definitely have to advise him about whether he worked on certain loans that the new job would want him to represent back, and if he is going to be covered by either the permanent ban, the official responsibility ban, or depending on his position, also the cooling off period.
What if the loans he has to work on are for a case involving HUD-related loan packages?
He can accept the position, but we are going to have to advise him on possibly staying behind the scenes if he worked on those HUD-related loan packages while he was a HUD employee, or if he is a senior official subject to the cooling off period.
May Ted talk? 4 months ago, Ted was a career SES who made a basic rate of pay to be considered as a senior official. Ted transferred to a GS-15 Step 10 position because it's nearly the same pay with less hassle. Ted was HUD's contracting officer on a $9 million contract with ABC International that ended 3 years ago. Now, last month, ABC International offered Ted a position, and he accepted, retiring from federal service. ABC International would like Ted to meet with his former HUD colleagues to pitch a new proposed contract with HUD. May Ted talk?
Oh, Ted thought he would be so clever switching to that GS-15 and not owing us a stock act form, but guess what? Ted was still a senior official during this time period. So it looks like from the scenario, he is still subject to the cooling off period for another 8 months, and he is not going to be able to meet with his former HUD colleagues to pitch that new proposed contract with HUD. He is going to have to wait.
And back to the future, it's the year 2026. And a former very senior political appointee, Robert Zemeckis, left HUD in January 2025 and now is employed with DeLorean Bank of New York, a prominent mortgage lender that originates FHA loans. HUD would like this former official to come back to headquarters and make a speech to current employees about his time in leadership at HUD in order to motivate the workforce. May he do so?
Yes, because this official is not representing the new employer, it's representing himself. So he should be very, very careful to make sure that he is talking about his time at HUD, that he is not representing he probably shouldn't wear the DeLorean swag, but he is not representing the new employer. He is representing himself, and he is talking about his time as HUD. So yes, this is permissible. And finally, and the reason why we're having this training is the great part is even after you leave the government, you can come back to us at any time, as often as you need to get rules about, to get guidance about these rules. In fact, when you're out there in the private sector, they might say, you know what, we want an ethics letter. And what they want is for you to come back to one of us and get us to write you a letter explaining these rules. If you work for multiple federal agencies across your federal career, the best advice is to contact the last agency you worked at to get that advice. And again, this is our contact information. So if you're at headquarters, Ethics Law Division at HUD.gov, or your regional counsel, or you can contact anyone at the screen. We are so glad that you joined us today, and I hope this answers a lot of questions about seeking and post-government employment.